Good morning. We are Senate. This is the Senate Judiciary Committee. Our first order of business this morning on Friday, February 11th, is S1 140, an act relating to civil arrests at the courthouse. And all we're going to do this morning is have a walkthrough of the bill by Eric Fitzpatrick, Legislative Counsel. Eric, you want to?
Sure. Good morning, everybody. This is Eric Fitzpatrick with the Office of the Legislative Counsel, here to do a walkthrough for the committee of S-140. It's entitled "An Act Relating to Prohibiting Civil Arrests at Courthouses," as Senator Sears indicated. And the bill really is exactly what its title suggests. It's a prohibition on civil arrests at courthouses. And it's important to understand that the term civil arrest is specifically defined in the bill to mean an arrest for purposes of obtaining a person's presence or attendance at a civil proceeding, including an immigration proceeding. So in other words, it only prohibits arrests that are made for purposes of securing a person's attendance at a civil proceeding. Doesn't have anything to do with a criminal proceeding. So this doesn't have anything to do with criminal arrests or arrests of a person for violating a criminal law, so that a person can be, either incarcerated or brought into court or arraigned, whatever it may be. None of that is encompassed by this bill. It only refers to prohibition on civil arrest, and it's an interesting background to the bill. In the first place, it's based on a statute that passed in New York, was signed in December of 2020. So I guess that's just slightly over a year ago. New York passed a similar statute. Language was different, so I rewrote the language, but the concept was the same: prohibition on civil arrests at courthouses. And it's based on a common law privilege that has been in the law for centuries, since it was in the law in England as far back as the 15th century. It was pretty much agreed upon that it was incorporated as part of American common law when the United States became independent. And interestingly, there's an excerpt I put on the committee's webpage if you want to take a look at it, and I'll read you from that. It's an excerpt from a Southern District of New York Federal District Court case decided about 2 years ago, December of 2019. And it sort of laid out the history of this common law privilege against civil arrests. And I'll just read you a couple of sentences from it. The decision provided that English common law provided a privilege against any civil arrests in and around courthouses, and also against civil arrests of witnesses and parties necessarily traveling to and from the courthouse. This is from an ancient sort of law dictionary. I say ancient, but it's several centuries old. Provided that suitors, witnesses, and other persons necessarily attending any courts of record upon business are not to be arrested during their actual attendance, which includes their necessary coming and going. The purpose of the privilege was both to encourage parties and witnesses to come forward voluntarily, and also to maintain order in the courthouse. Privilege was adopted into American common law after independence, and it was never thought to apply to criminal arrests. So again, it only applies to civil arrests, which don't actually happen that much anymore. It's another interesting discussion in the opinion. It's originally based on the idea that right now, if someone is sued civilly, the way that a person is notified of the fact that they're being sued is by service of process, right? We have this, that's our practice currently, and has been for many years. The sheriff or somebody will serve process on the person and let them know, hey, you are the defendant in the lawsuit. But for many centuries before that happened, before service of process was developed, a person could be civilly arrested when they were being sued. And that's how they were notified that they were being sued. Obviously, that doesn't happen anymore. However, the court went into a great discussion of the fact that this common law privilege against civil arrest nevertheless still exists. And one of the places that it would be appropriate because of you think of, well, when is someone arrested to appear in a civil proceeding anyway? Does that even happen anymore? Well, one of the instances in which it happens is in immigration proceedings. Immigration deportation proceedings are civil in nature. They're not criminal. And as I think probably everybody knows from various media reports, sometimes people are arrested civilly in order to be brought before an immigration court to be deported. So that's the genesis of both the statute that passed in New York and S-140 that you see in front of you. The idea being that if a person is going to be arrested to appear at a civil proceeding, whether it's an immigration proceeding or any other, it can happen at a courthouse. It could still happen somewhere else, some other location, out in public, grocery store, walking on the street, whatever. This bill doesn't apply to that. This only provides that the arrest cannot take place when a person is coming or going for a court proceeding for some other matter. That kind of give a big picture background.
Yeah.
What the bill covers.
It's also fascinating, quite frankly. I had no idea.
Yeah, I didn't either until I researched. It's very interesting. It had this case that I can send you the whole link to it. I just put excerpts from the case on the website.
No,
but the whole case is very interesting.
No.
Sounds something similar to when a legislator is driving to the State House and you have to be released if you get stopped for speeding.
Yes, it's true. Yeah.
It's funny. I also thought the same thing. Eric,
It's interesting that you both mentioned that because that exact privilege was discussed in the court case as being sort of an analogous situation and that's in it's in the federal constitution as well.
Huh.
Eric, I'd be interested if you find any history just to see if this has ever actually happened in Vermont, because I've never heard of it happening, and I'm curious as to what it is we're going after here.
Yeah, I'm not sure either. That's a good question. I know that the New York statute was based on instances of, I think, people being arrested while they were going to a court proceeding because it was known that they would be present at this court proceeding, and they were arrested there in order to bring the person to an immigration deportation proceeding. I don't know that it's happened in Vermont. I don't know. I read about that happening in New York, and that was the sort of genesis for that statute.
Well, if you stumble across anything, I'd like to know.
Yeah, absolutely. So the language of the bill is, as I said, it's a prohibition on that, on the arrest of a person who's attending a court proceeding in good faith as a party, juror, attorney, or witness. So if you're attending the court proceeding, it's in one of those capacities. So you're a party to the case, or a juror, or attorney, or a witness, then you can't be arrested for a civil proceeding. Again, that doesn't. If there's criminal charges against the person, of course, they can still be arrested. This is for a civil proceeding while they're traveling to, entering, remaining at, or returning from the court proceeding. Now, there are some exceptions to that. So if the arrest is made pursuant to a judicially issued warrant or court order, it could still be made. If it's an arrest for contempt of court where the proceeding is occurring, if you think about it, that's sort of a logical exception. In other words, if a person is being held in contempt for the proceeding right there at the court, then obviously they would still be able to be arrested for civil contempt because that's also a civil proceeding. Or an arrest to maintain order or safety in the court where the proceeding is occurring, also an exemption. Now, this is not a crime. So just so you notice under the penalties, this is not a crime. It's a prohibition, but it's not creating a new crime. So the language provides that a person who violates it, in other words, a person who violates the prohibition and does arrest somebody in that sort of situation, they could be subject to civil contempt proceedings, and they could be held liable in a civil action for damages. So it doesn't create a crime, but the person could be, the penalty is either you could be held in civil contempt or you could be sued for damages under subsection D of the bill, which establishes a private right of action. So the bill also does that. Sorry, go ahead, Senator Sears.
To be totally honest with you, Brian, Eric, my memory, I took my Prevision this morning, but my memory's a little foggy. And I believe the governor and the attorney general and a group of people urged us to pass a bill early in 2019, I think it was, following Trump's, having sheriffs be required to arrest people for ICE. And is this bill similar, or is it a companion to that? I mean, I just don't remember all the details of the bill, but I remember reporting it on the floor, and it was strongly supported by the governor, the attorney general, and others. I think it was
What bill are we-
2019.
What bill are we looking at? I apologize for just getting here. My computer just died.
140.
Well, S-140,
140.
S-140,
Okay,
and it has to do with civil arrest when you're, it's S-140.
Yeah.
And it has to do with civil arrest at courthouses. It prohibits that and creates a private right of action if you are. And it's mainly to deal with immigration. Evidently, immigration has been known to, at least in New York, to go after and try to deport immigrants who may be at court in a civil matter or as a juror or whatever. And my question was, if this fits in with, welcome, Marley, this fits in with the, I think it was 2019 laws that we passed regarding not having Vermont police be able to work, do work for ICE.
Yeah, I do recall that as well, Senator Sears. And I think that one could view it as, it does something different, but I think you're right that it's connected. It's related in the sense that it grows out of the situation of ICE taking actions against, or at least allegedly taking actions against unlawful immigrants or people who may not be unlawful immigrants.
Before next, I think we got it scheduled for next Wednesday, but before then, it would be interesting to know at exactly where, how this could be a companion to that and make sure that it fits in.
Yes. Yeah, I can look into that for sure.
Okay.
Just to say one thing further on that, I don't think it was a bill, though, was it? I think it was just something that was practice. Because I know
I think it was a bill because I reported
It
it on the
was.
floor.
it was a bill, because I know that the enforcement of that bill, some people still violated it with regard to some of the migrant workers.
Well, there were allegations that they.
Yeah, I mean, the people were picked up. So
I don't want to. Yeah, I think we're. I just want to make sure we're.
yeah, no,
in
good idea.
concert with that.
Mhm.
I'm pretty sure it was a bill.
it was.
It was.
Yeah, I can't remember the
S7 or-
number, but what was it? S?
7. I keep in my head, I keep hearing S7, but
Right.
and it was like not the last session, even it was the session before that. It was like 4 years ago or 5 years ago.
It was right after Trump took office, and it was a concern that he had ordered. If you remember back, he wanted to go after illegal immigration.
Mhm.
And there was quite a push to not allow it in Vermont, and other states did the same thing. So we didn't want our police officers to do that. Then there was questions about up at the border in Swanton. As I recall, there was some concern about that. But anyway, you should continue, Eric.
Well, actually, that's the private right of action was the last piece of the bill, actually, that
Right.
I had already mentioned that the definition of civil arrest, and it provides for a private right of action, which means that a person can be sued, a person who violates it can be sued for damages in civil court, in the civil division of the Superior Court. Additionally, the Office of the Attorney General is given authority in the bill to bring an action on behalf of the state if there's a reasonable cause to believe that there's a violation going on. And there's some immunity in there for the judiciary or any members of its employees for actions taken to maintain safety in the courts. But really, that's it. It's a prohibition on the civil arrest of a person at a courthouse. It only applies to for civil purposes, not criminal. And it, as you indicated, Senator Sears, it provides a private right of action for damages as well.
Thank you.
You want us to ask questions now or wait until next week?
No, you can ask questions now. We
So,
got about
Eric, I'm
10 minutes.
Okay, I remember the bill and I took some heat for voting on it, but my brain told me that there was a line of demarcation between state police, law enforcement, and federal officers. And the line was being blurred between who was operating in whose jurisdiction. And for that reason, I voted for that bill. Here, I'm just thinking about my own courthouse. There is often a line of people waiting to get through the metal detector. I think the intent of this bill is to not allow a court officer who is letting people come in arrest someone in an immigration issue, because that again would blur the line between our law enforcement and the federal law enforcement. But if out on the sidewalk, there is an immigration officer who recognizes individual A as an illegal immigrant and goes to arrest that person, do I understand this correctly, that that immigration officer would now become subject to liability with this
Yes.
bill?
Yes. And I think, I don't want to put words in the mouth of the sponsor, but at least based on what I read in New York statute and the Southern District of New York case, I think that's part of the purpose as well. I think that's the intent.
Huh. Okay.
Yeah.
All right. We're going to pick this up on Wednesday, and I know there'll be a lot of testimony about it, but I too want to understand it better, but I'm always fascinated by old laws, and the fact that this came from England in the 15th century. My Lord. This is a problem that led to the establishment probably of side judges in Vermont. That's another interesting history. The side judges are here because the Vermonters were scared to death of lawyers from New York. And the Yorkers were trying to take over our counties, and that's why and they were the judges usually. And I am especially pleased to have Justice Eaton here as we discuss the history of the Vermont.
Yeah, the backstory of this one was, like assistant judges, as you were mentioning, Senator Sears, it was very interesting. It was
York lawyer didn't do something.
right. I learned a little Latin too. One of these old, 18th century English cases that was cited in that Southern District of New York case was saying, well, the privilege was someone was entitled to the privilege from arrest iundo e rediadundo, which means going and returning, evidently. So, so if you were going or returning from the courthouse, provided they came bona fide, is the next line, then they were privileged from arrest.
All right. Well, thank you all for, I see a number of witnesses here, including Justice Eaton. And I know Justice Eaton is very familiar with the assistant judges and how they became part of Vermont law, as it were.
Yes, indeed.
And I truly appreciate your being here, Justice. We're here on actually a very serious matter, and that is the opening of the courthouses. And I expect that there may be some legislation to provide more flexibility for sheriffs. But I also recognize that part of the problem is that courthouse security is preventing you from opening certain courthouses. And so we're actually to do two things here. One, look at maybe any legislation that's needed. I've long believed there is legislation needed to give more flexibility with courthouse security. Obviously, there's also a need for more money. My understanding is the governor's budget doesn't get anywhere near what the judiciary needs to be able to adequately secure its courthouses for opening. And we keep hearing from various counties where cases have been dismissed. The judiciary is forced to negotiate with 14 different sheriffs. And many of the sheriffs are having difficulty filling positions. So all of that calls to me for more flexibility. And if it needs legislation, I have some suggestions actually that I'd like to propose later. But I think first, for the scope of the problem, I'm going to ask Justice Eaton to lead us off and Judge Zone to be able to jump in. And I see, is Scott Griffith here or is not coming? I don't know. But Justice Eaton and Judge Zone, you're welcome to tag team or let Justice Eaton go first and do whatever what you want.
All right. Well, thank you, Senator. Judge Zone and I have talked about it, and I guess I'm going to go first here. So I appreciate the opportunity to be here today, and thank you all for your interest in the issues that we're facing. As you know, it's been a struggle with the COVID virus to get our 23 sites up and running, but we've been able to do that in large part, not in all locations, but in many. But that has come only through the assistance and cooperation of BGS with respect to the state buildings and the assistant judges in the county buildings. In many of the locations, we've modified the courtrooms and their usage. And in many locations, we've improved air quality, and we've certainly done that wherever we could. And the cooperation of both BGS and the assistant judges has been steadfast, and it's been vital. That work in continuing to improve the physical plants continues. There are locations right now where there are more things that can be done, and we're working on doing those specifically in Newport and in White River Junction. But as we come out of the COVID situation, at least I hope we're coming out of it, there is a large backlog of cases, as you might expect. And Judge Zone can speak more specifically about those numbers. But it's certainly safe to say that it's more important than ever that we be able to use the facilities that we have as fully as possible if we're going to be able to dig out from underneath this backlog. And we're quickly approaching a time as the virus recedes where there will be an increased need for more in-person hearings and, of course, for jury work. Although I expect that remote proceedings will continue to be done more than they were pre-pandemic, they are not the solution to all of the needs that the judiciary have. So we are facing, I don't mean to overstate this, and I don't think I am, but we're quickly facing a crisis with respect to security. We're already feeling the pinch due to a lack of security in several locations. Our operations are less than they could be in several places. In Grand Isle, we've pulled in security from other locations and taken it off from the Supreme Court just to get the building accessible to the public for 4 days a week. That's not to say anything about conducting hearings in there. If we had additional security, we could open it for a 5th day. In Windsor County, due to a lack of security, we can operate either White River Junction or Woodstock, but we can't operate them concurrently with the security that we have. We've also faced cutbacks in Orange County. So even now, before we get fully back operating, we're hamstrung by a lack of security. And I have been practicing for a long time and been a lawyer for a long time. And I remember fondly the time when we could walk in and out of the court buildings without security. Those days, unfortunately, are gone. It's neither safe nor prudent to operate our courts without adequate security in the world that we live in. So it doesn't matter that we've created suitable space for hearings and trials in terms of the air quality if we can't secure the locations. What we need is security that's adequate, and we need security that's stable as part of our service to the public. Now, most of our security is provided through contracts with the sheriffs. We have either 12 or 13 different contracts, which seems a bit unnecessary to me, but that's the reality. Those contracts, it's my understanding, include a provision that the sheriffs can opt out of providing security with 30 days notice to the judiciary. And the sheriffs have already cut back on security in several counties. Now, the reasons for that, as I understand it, is either the money that the courts can pay is not adequate to meet the sheriff's costs, or the availability of personnel, or both. And that has put us in a very unstable position. It's important for us that at each of our locations, we have at least one person who has arrest powers. The reasons for that are that people show up under arrest warrants and want to surrender. Sometimes the judge has a hearing and takes the person into custody. And also the need for security with arrest powers to detain during an event that might arise in the court. So all of that means that under the present structure, we need the sheriffs to be involved in our security. And the judiciary has had a long and very good relationship with the sheriffs, and it's an important partnership. But we understand that not only are the sheriffs a law enforcement agency, they're also a business. And we simply can't pay as much as the sheriffs can make doing private contract work. That's just the reality, and we will always be outbid on work if it's going to the highest bidder. The judiciary is not seeking to blame the sheriffs for the current situation, but the reality is we cannot run our courts without them unless we restructure the entire system. Now, right now, we've got trains running in 2 different directions. Our security needs are and will be increasing, and the availability of security resources from the sheriffs is decreasing. It's imperative that the resources we get from the sheriffs be stable and dependable and used as efficiently and effectively as possible. And as we've talked about flexibility and agreed with Senator Sears, there's a need for flexibility. Part of that flexibility is to look for and identify ways to more efficiently use the resources that we have, including the sheriffs. And on the other piece, the money piece, we have asked for $1.475 million for security. And the governor, in his recommended budget, has recommended half that, $750,000. At $750,000, that would allow us to raise the money that we pay the existing security personnel to $37.60 an hour. If we were to get the additional $750,000 that we hope we will get, that would enable us to raise the salary of existing personnel to $45 an hour. And under either scenario, that's less than what the sheriffs say is their costs, and it does not afford for any new security personnel.
Did you say $45 an hour?
45 an hour. Yes, I did.
Thank you.
What we need then is the additional $750,000. We need adequate resources to keep people safe and get cases heard. Because if we can't get cases heard, we're not going to get out from under this backlog. There's a ripple effect. If we get cases scheduled to be heard, they resolve, and other cases resolve under the threat of a trial or a hearing. And the private practitioners are jammed up and can't get their cases heard, and we need to address that. But overarching all of this is we need stability in the resources that we have. We cannot live with a 30-day notice if the effect of sheriff exercising that 30-day notice is to shut down our locations. So no blame being pointed here. We have a problem on our hands. It's got to get solved, or it's going to get worse. And when it gets worse, it's going to get worse quickly. So thank you very much. If you have any questions, I'll be happy to answer them, but Judge Zone can provide additional commentary.
Okay, I have a couple of questions, but if you were to receive the full 1.475 million this year, you would still have a problem in some counties because they're, number one, the sheriffs want more than what the $45 an hour?
Yes, sir.
Some sheriffs want more than $45 an hour. And you'd also have a problem because some sheriffs don't have the deputies available because they still would make more money directing traffic or serving warrants or whatever else they do.
That's right. Or maybe
But I
they simply
also-
don't have the personnel for whatever reason.
Yeah. How bad is the backlog?
Judge Zone will, when he testifies, will give you the specific numbers. It's significant.
Okay. Do you have the staff in the judiciary, if you had security, to clean up the backlog?
Maybe not all of it, but we could make some inroads. We have right now a window, a 2-year window where we can use some limited service positions that gives us the opportunity to put additional staff in for this period of time for the next 2 years.
Yeah, I know in Bennington County, they've shortened the hours at the probate and civil court room on North Street.
Yes.
Or South Street. And, I don't know, I mean, Sheriff Schmidt tried to work out with the judiciary because he wasn't getting enough and allowed you to pay a little bit more. But that's the type of contract and type of negotiation that appears to be going on because you're doing 12 or 13 different contracts. Is that
Yes.
correct?
Yes, the situations are somewhat different in each county.
And then you have in Windsor and Chittenden County, you have Pago. Is it Pago? Some kind of security. I don't.
Oh, Securitas.
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 That's
Why
in,
did I say Pago? That must be some other company.
it's primarily in
Securitas.
Wyndham.
Okay. And we've all heard about the problems in Wyndham County where somebody comes to the courthouse to turn themselves in and then they have to go to the police department. All right, Judge Zone. If Senator White has a question or comment.
No, I'm sure that this will come up in the additional testimony, but when $45 an hour sounds like a lot, but the sheriff's offices have to provide the vehicles and all the equipment, so it doesn't anywhere near cover their costs. And I'm sure we'll hear that.
Yeah, but I'm not sure vehicles are required for courthouse security though.
The vehicles wouldn't be, but the equipment would be.
Thank you all.
Also, I wanted to ask Judge Zone if you would touch on the move from transports to and from court, from jail to arraignments that are done by video. And Justice Eaton spoke a little bit about that. Those types of arrangements will be increasing.
Well, good morning. Thank you for inviting me to testify today. Tom Zone, Chief Superior Judge. Justice Eaton highlighted many of the issues that we're facing right now. And Senator Sears, you asked the magic question, and that is, what's the backlog look like? I have statistics from June of 2019, which was the end of the fiscal year prior to the pandemic. In June of 2019, we had 2,401 active pending family court cases. On February 1st of 2022, that number is 3,450. That's an increase of 1,049. In June of 2019, in our civil division, we had 4,719 pending active cases. On February 1st of 2022, we have 5,627, 908 cases higher. And the criminal division, in June of 2019, that number was 8,209. On February 1st of 2022, that number is 14,900, increase of 6,691 cases. So when we talk about the backlog, those are the numbers that we're looking at. How do we address the backlog? We have, at this time, the ability to conduct jury trials in every county of the state except for two, Grand Isle and Essex. We've taken steps, as Justice Eaton has talked about, with HVAC. We've taken steps to make the buildings safe so that people can enter into them to conduct the important business for in-person hearings and jury trials. The opening up of the courts in a way that we have been able to do it has directly led to actually decreasing numbers. In other words, if we would not have met with the success that we've met with in reopening the courts and getting the counties doing jury trials, these numbers that I just read would be even higher. It's well known that in the criminal justice system, one of the most motivating factors for resolution is the jury draw and the jury trial. And for instance, I'll use Senator Sears, your county. On February 1st, there was a scheduled jury draw. There were 13 cases that were on the list. Of those 13 cases, 11 of them resolved through plea agreements or dismissals. One of them was scheduled for the trial, and one of them was continued for other reasons. Those cases would not most likely have resolved had we not had the ability to have the jury selection with the trial coming after that. I understand, I believe that 3 of those individuals were incarcerated. I have contacted judges in our other counties. In the other counties where we're going forward, we see similar results. When we schedule the jury trials and the jury selections, it does bring the parties together, it leads to resolution, and that has a ripple effect. Not only, this is not just, I give statistics, I give numbers. This is about people, as we all know. This is about families. This is about how it impacts the state's attorneys, the public defenders, the private attorneys, the victims. Our ability to deliver and go forward impacts all of us in Vermont. And the reality is, in order for us to continue moving forward and reopening our courts to get back to normal, whatever that will look like in the future, we need adequate security. To echo Justice Eaton, it's not just a matter of what we've done inside the building for safety as far as the pandemic. It's that front door, because the world we live in is not the world that, when Justice Eaton mentions the old days of going to courts without security, those days are gone. And our partners, since I started 15 years ago, have been the sheriffs. We've relied on them. They've done an exceptional job providing safety and security for our buildings and the staff, the judges, and the persons who have come into our courts. And we need to find a way to continue that, because without the ability to maximize the resource of security, we're not able to have those jury draws. We're not able to have those cases be able to get resolved either by resolution, dismissal, or alternative means, or by trial. In going forward with reopening, we have had the ability to work with our partners. And I know that I think in Orleans County, at least, the sheriff there has assisted us with allowing the state transport deputy, I believe, has actually been shifted over to security. We had the first draw back in January in Orleans County. It was that type of maximization of resources that allowed us to have the cases move forward in that county. And that's the type of approach we need to take going forward. And that is, we recognize the sheriffs have issues on their end. We want to work with them. Senator Sears, you ask about the transports. We should not have deputy sheriffs sitting in courthouses all day with transports, waiting to get heard in cases. That has happened. I can assure you that those are messages that I'm talking to judges about, and we recognize that that's not the appropriate utilization of what sheriffs should be doing. We need to maximize their time. When we have a transport, they should come into the building, address the important matter they have to address, and not just sit around all day waiting for the schedule. They need to be getting back out on the road to continue other duties. We recognize that there are many times we need to have the defendants in criminal cases brought to the building for proceedings. There are also times when we don't need to have the defendants actually be transported. We have shown in moving through the pandemic that there are times we can do status conferences, other appearances, whether they're arraignments or even changes of plea and sentencing. We can do that remotely if everyone agrees and we work forward in that direction. We need to maximize the technology. That also calls into the equation our partners at DOC. DOC has to have the ability to deliver there also. And I know from speaking with them that there's been some concerns about their ability to provide us the technology backup, if you will, that they can't always deliver to have us do remote hearings. There's also been comments made that, well, they can't even give the defendants paperwork to sign and send back so that we can complete the case, but rather we should have the person transported to court to do that. Now, I know that goes directly against what I think many of us are trying to accomplish, and that is cut down unnecessary transport. But it does highlight
logic too.
It seems to me that if DOC is able to have the resources to assist us in at times having paperwork delivered to individuals to sign and send back, I know that there's times that results in the case being resolved and the defendant possibly even being able to be released at that time to no longer be in their custody. And so it seems to me that the approach that we need to take is one that maximizes the use of the transport deputies, minimizes the times that we are, I'll say, wasting their time sitting around doing nothing, and recognizes that there is technology that can assist us. And again, technology is not a replacement for in-person hearings, which are necessary, but it can be used to minimize the necessity of transports at different times when we don't have to have the in-person proceedings.
So if I might ask a few questions, the first,
Absolutely.
If you have those figures on the backlog, I was trying to write them down, but I know I
do.
messed them up. And if you could provide Peggy with those so we could post them on our committee page, it'd be very helpful to look back on. Second, my actual question is, one of the problems seems to be this idea that we have these transport deputies available. There's 25 positions. I don't know how many of them are filled. I'm sure John Campbell can give us an idea. But in many cases, they're not needed for transport. I know in Windsor County, they're actually transporting people who've been arraigned remotely back to Windham County in order to, because they have no means of transportation. They've been released remotely, but they're stuck in Springfield or wherever they're were, or going back to Bennington or wherever. So that's one problem that needs to be resolved as we go forward with more remote hearings. Secondly, I would assume that, and I didn't ask corrections here and I should have, but I would assume that we have people incarcerated because they're waiting for a jury trial, which can happen. You just spoke to. I noticed in the Bennington Banner that perhaps one of those cases, the guy had already served 2 years. And so once the plea deal was reached, he was released. So I would expect that the backlog might actually reduce prison population to some extent.
I absolutely
be-
believe that, yes, that once we resolve the cases, that will allow people to move forward in the Department of Corrections, whether it's with programming or meeting their minimums. It does definitely bring with it the possibility that we're going to reduce the corrections population.
Because whatever they served on detention counts against the ultimate sentence. So that's another factor that we should weigh here. Are there other questions for Judge Zone? Senator Benning.
So Senator Sears, I just wanted to touch on a point that was brought up by Judge Zone, and that is the Department of Corrections has recently issued a directive to its caseworkers that they shall not accept via email a scanned change of plea form for incarcerated individuals to have to sign and then scan them back to the attorneys who have sent them in. That is problematic, and I don't know how to resolve that without inviting the commissioner in, the commissioner of the Department of Corrections in to have a serious chat about that being a problem. The other problem that has surfaced, and Judge Zone, I'm not sure if you're aware of this yet, but the Department of Corrections has suddenly stopped allowing plea agreements to come through that have a component of a work crew requirement. And that literally this week, I had 18 cases on for status conferences or changes of plea on Monday. 3 of them couldn't go forward on changes of plea because they had a work crew component attached to them. Now, the excuse that I've been given is that it's a COVID problem. But this is problematic because it's backing up cases that are ready to go through and be resolved, and in some cases get people out of jail. But it is only contributing to the backlog, and I don't know what kind of pressure can be put on to get that reopened, but that is a serious problem in trying to get some of these cases moving.
Thank you for mentioning that. I had not been made aware of that, and I'm going to follow up on that right now about the work crew. My understanding was that that was something that was still available, and so I will check into that.
Thank you.
If at a future meeting, I expect there will be a future meeting on this subject. I'll be sure to invite the Department of Corrections. Frankly, I just didn't. And now I see I should have, but I didn't. I'll take responsibility for that. Other questions for Judge Zone? Thank you, Judge. I think there will be other questions as we hear from others. I believe Assistant Judge McKinnon is here, who's the chair of the assistant judges, who we spoke of earlier in their history in Vermont. And I remember talking to a school group and they wondered why we had assistant judges. And I was trying to explain that to them. And I stumbled, but I basically told them we didn't trust Yorkers back in the 1700s. And we still don't trust them.
So, good morning. I'm Joyce McKeeman. I'm an Orange County assistant judge. I've been an assistant judge. I was elected in 2010. I'm now president of the Vermont Association of County Judges, which is the name of the organization that represents the state's 28 assistant judges. Thank you very much for inviting me to be here today. I know that you've got many important guests and that the topic might be centering more on court security, but I do want to take this opportunity for anybody who isn't real clear about the role that assistant judges have played and will play in making sure that we reopen all of our courts and courtrooms to their full use. As you probably know, the elected assistant judges wear two hats. We're the sole county administrators with responsibility for our county courthouses and the county budget. The county budget does provide basic support to the sheriff's department, does not pay for law enforcement personnel, but we would not have a direct role in funding hiring of deputies. In our judicial role, we sit on both family and civil dockets in Superior Court. I'm here to just real briefly touch on how we could assist in the efforts to reopen the courthouses. As you know, assistant judges' authority to raise funds and what we do is limited by statute. However, because we can raise funds for the maintenance and the upkeep of the county courthouses in the first months of the COVID pandemic, the assistant judges were able to pivot quickly to meet the challenges that we were faced in bringing the public and the staff safely back to work in the buildings. We've continued to cooperate with efforts by the judiciary to upgrade HVAC systems and to make other changes as necessary to make those buildings as safe as possible. I'm very proud of the fact that in my historic county courthouse in Chelsea, that we're fully able to resume all court operations, including jury trials. That's in large part due to the fact that we had an existing HVAC system, but we worked diligently and quickly with the judiciary, with Greg Mousley and with not with BGS, but with everyone to bring our system up to its fullest functioning so that we could resume jury trials. What is hampering the full use of county courthouses, and again, I know my own courthouse is better than others, is that we do not have security. We are fortunate in that the Orange County Sheriff is continuing to provide front door security in Chelsea, and therefore the courthouse is open 5 days a week during regular court operations hours. However, we no longer have deputies providing courtroom security, and that is hampering our functions. We are keeping in close touch with the judiciary in their efforts to work to find solutions to this. To that end, the assistant judges met this week with Judge Zone and Justice Eaton to get the most recent updates on the challenges facing the judiciary as it attempts to reopen all of the courthouses and courtrooms. And I stress courtrooms because there are two courtrooms in Chelsea, and we're only using one of them for in-person hearings because we only have one court officer available a few days a week, and the priority is given to jury trials. We have conveyed to Judge Zone and Justice Eaton our continuing commitment to make whatever changes we can and to support the judiciary however we can to reopen to full functions as quickly as possible. We are disheartened to learn that the budget presented by the governor did not provide the funding that the judiciary was seeking to improve the security situation. So it is often said that the assistant judges are the eyes and ears of their local communities, and that is true. And so I think that we are maybe not uniquely positioned, but equally well positioned to be able to see and observe impact of limited court operations on our local communities. We know that there are families waiting to get into hearings. Families are deeply impacted beyond the person who might be a party to some court proceeding. And those families, there are ripple effects through our communities because not everybody can get in to use the courts as quickly as possible. So to that end, I'm here to possibly answer questions as to what our role is, what our role could be, and any questions that might come up. But again, I really do thank you for inviting me here today. Um, it's common that people don't fully understand all the different hats that the assistant judges wear. And I don't mean to presume that anybody on the call might not understand all of those hats, but I'm happy to answer any questions as I can. Thank you.
I got my first question, Judge, would be regarding the funding for the sheriffs by the
Yes.
counties. It's really confusing for me the more I delve into sheriff funding. They get money from the counties, they get money from the state pays for the sheriff, they pay for the state paid deputies, and routinely pay for courthouse security through the budget, but not enough. But the judiciary does pay for courthouse security. What do you pay? Not you personally, but what does Orange County pay the sheriff for? I know in my county, there's like $100 and something thousand goes to the sheriff. What does go to the sheriff from the county budget?
I apologize that didn't have that figure right in front of me.
Well, I don't need the exact figure. What is
So-
it you're paying for?
Well, we can only pay what we are authorized to pay by statute, but the statute is a little bit vague. So the variety of support the sheriff's department is rather extensive county to county. The Orange County budget, about 2/3 of our total budget is devoted to supporting the sheriff's department. That right now that is in upwards of $400,000. Part of that reason, my understanding from our sheriff, is that he does not have sources of income available to him that might be available to other sheriff's departments. So for example, the statute allows the assistant judges to fund equipment as is necessary in the assistant judge's view. And I probably am not quoting this exactly, but in our view, equipment that is necessary to perform the law enforcement functions of the sheriff's department. And again, that's not verbatim from statute. So what equipment does that mean? That's pretty vague. We are authorized to pay for training. What kind of training? That is vague. And the training budget for the sheriff's departments, it varies quite a bit from county to county. Right now, in Orange County, we provide $35,000 a year for training, but that wouldn't even pay the cost of 2 deputies to go through the basic training at the police academy. So we can't pay directly for a deputy's salaries, but in all the other ways. I mean, in Orange County, the statute says we are to provide telephone service. In 2022, it's not sufficient to provide one landline to the sheriff's department. So in our county, we are paying for upgrades to mobile Wi-Fi that is used in cruisers, for example. So again, I'm most familiar with our sheriff's department and what we pay to support our sheriff's department. But I will say that in general, the statutes regarding what the county budget can be used to support is quite vague. I'll just say that there's a lot of gray area.
I wonder if Legislative Counsel Eric and Stephanie Barrett from the Joint Fiscal Office are here, and I would appreciate a better understanding before we do the 2023 budget of what is it sheriffs are getting from county budgets versus what are they getting from the state. I hear, Justice Eaton started out with the sheriffs are a business, and I understand they're a business, but it's an odd kind of business. They're receiving money from the state, receiving money from the county. They're having contracts with towns within their counties, contracts for a variety of different things. So it's confusing at best. So we hear that that the sheriffs need reimbursement for their vehicles when they're doing transports. But then we hear that you're providing the vehicles through the county budget.
No, that's not correct.
Well, you did
there
say,
is-
you said that you're providing vehicles.
No,
I
we
thought you
provide,
said vehicles.
I didn't, I'm sorry. If you heard that, either I misspoke or the connection wasn't clear. We specifically do not provide vehicles. We provide equipment. The statute allows us to provide equipment. There's one Supreme Court case from the mid-70s, Stowe v. Lamoille, which is the only case which lays out in some degree of specificity what counties can pay for and what they can't pay for. And that decision made it quite clear that we can't pay for vehicles. So we do
Okay.
not pay for vehicles.
Well, maybe I heard the word equipment and I thought that was included vehicles.
No,
Well, what
sorry.
equipment? Maybe not today, but I would like to know what the equipment is that my property taxes are paying for.
Right.
And what is it that, I believe in Bennington, it was about 130,000, 150,000 going to the sheriff from the county budget. And you said yours was 400 and something thousand.
Yes, I know that Orange County is on the high end. So I'll leave it there. I'll leave it there. Yeah.
Okay. Well, I appreciate your testimony and I really do. I really would like Eric and Stephanie, if they're able to check more into what is it that's coming from the county to the sheriff.
So
Senator Benning
Sears-
has a question. Yeah, Senator sorry.
So you want us to survey the counties and understand how much and for what?
What are they buying?
The budget.
Now, what are they contributing to the sheriff's budget and what is the equipment? And what I heard here was that the communications equipment for or at least the telephones, I would assume cell phones and landlines for the Orange County Sheriff are paid for by the assistant judges or the county budget, I should say.
The county budget, correct.
So I'd like more to understand better what it is taxpayers are paying.
Okay.
Okay.
So am I
Senator
right
Benning.
to ask for a quick question, Senator Sears? Am I right that you're not asking a statutory question? You're asking a question as a practical
I'm
matter?
asking both the statutory, what are the statutory limits to what the county can pay? I'd like any statutes relating to what counties relationship with the sheriffs and what can they pay for, what they can't pay for, anything that's in the statutes.
Right.
Right. Title 24, Section 73 deals with county support for the sheriff's department. It's a pretty short paragraph.
But you said it's vague, so,
It is vague.
okay. Senator Benning has a question.
Judge, just two brief questions going away. Does Denise Gladding still work in your building?
Denise does not. She retired quite a number of years ago, Senator.
Okay, well, the other person I would ask you to say hello to is Sheriff Bonyak, and don't be surprised if he giggles.
I will indeed. I will indeed.
Thank you.
You're welcome. Thank you.
Any other questions for Judge McKinnon? Judge, thank you for being available. I really appreciate it. It's always good to hear from the assistant judges in here. Many years ago, this committee is the one that kept a vital role for assistant judges and things like uncontested divorces and other stuff.
I'm
Your
well
role
aware,
is
Senator.
important. Your role is important, and keep up the good work.
Thank you so much. And again, thank you for having me today.
Yeah, and there may be questions that come up later. What I think we're going to do a second edition of this discussion. So we would like to have you involved in that as well.
However,
So
I can be helpful.
Yeah. The next scheduled witness is John Campbell, but I know that Sheriff Marcoux has to run. Well, he's not going to run, but he's probably going to drive to wherever his meeting is. Do you want to let the sheriff go first, John?
Whatever's up for Sheriff Marcoux, if he would rather do that. I've got some, just kind of give you an idea of what we have planned to try to help out.
I've got some thoughts too.
So we'll let Sheriff Marcoux.
Okay.
John, I'm good. If you got something like 10 minutes and I can have 10 minutes, I can still make my 10:45 getaway here. So I defer to you, if that's all right with the Senator Sears.
How about if I just give some basics then within that time frame, Senator Sears? Would that work?
That's fine, John, Senator. Everybody's
That's
a
okay.
senator.
Call me. I get called a lot of things.
Well, you're a former senator, so we can call you Senator Campbell.
First,
I made a mistake in calling Senator Barrett. She is the Joint Fiscal Office representative.
She should be a senator. I think she's like the 31st.
She should be.
senator.
She'd be a great senator.
Yeah.
She actually, her function in the Senate Judiciary, Senate Appropriations Committee is really an excellent one, and she should be a senator.
Yeah. Senator, first of all, John Campbell, Executive Director of the State's Attorneys and Sheriffs, for the record. I really do want to point out what Judge McKeenan had mentioned. The side judges, just so you know, the assistant judges are really going to be very instrumental in the reopening courts. Maybe not the criminal aspect of it, but certainly in the family courts and what they do. They do a great job. So I'm glad that they're on board. Also, the security issue that Justice Eaton had mentioned, it is very real. Last week we received, I think, 3 or 4 different threats on our state's attorneys or our staff. And in fact, one of our deputy state's attorneys in Windham County was assaulted this week, and charges are being brought against the individual. But this was an actual physical assault. So security is an absolute necessity in our courtrooms, unfortunately, today in courthouses. And in discussing this issue, which we know is really in crisis, in a crisis stage, I've been working with the Court Administrator's Office and also the Sheriff's Association, with Sheriff Anderson and Sheriff Marcoux, to try to find some type of solutions here. And everybody's been trying. I think we're all thinking outside the box. We're all trying to do whatever we can to remedy the situation. I received actually a letter from Chief Justice Reiber yesterday, and who detailed about the crisis of the court's ability to reopen and the security issue, and asking for our help, which I believe that we have. It's incumbent upon us to do what we can to assist the courts to make sure that provide security. So what I've done is I see this as really 2 steps. One is a temporary step, and that's and then the other is a long-term solution. The long-term solution, of course, is what the Court Administrator's Office is doing now with the sheriffs to try to negotiate a contract. We went over the actual numbers of cost, and Senator White was absolutely correct. We're not talking about just the salaries. You talk about with salaries, benefits, other incidentals. It does go close to that $50 an hour. Annie Noonan has those figures if you need those. But the fact is that it's not inexpensive to have to pay for the full-time sheriffs or full-time deputies. So those costs are in fact real, and so any help that the legislature could do from an appropriation standpoint, I think would go a long way. And I definitely believe that that it should be over the governor's recommend on that. I'm not sure that the administration was aware of the severity of the problem, and that might have something to do with it. But the temporary plan is, and actually today I've asked the executive board of the Sheriff's Association to meet with me to discuss the possibility of reallocating some of the transport deputies to the courthouses to serve as security in this interim period. The reason I'm meeting with them is the statute calls for the decision to be made jointly between my office and the executive board of the Sheriff's Association. And so they're going to have to agree with me that that we can reallocate. I've looked at our numbers for transports; they're down significantly. Like to give you, for instance, I had them here a second ago. We had in let's say Caledonia County for 20, it was 297. In 21, there's 6. Bennington County was 455 transports in 20. There are 74 from year to date from June or July 1st till now. Chittenden County had 714 in 20, and they've just done 51 up until from July till now. And so
they have six state paid deputies.
Yes. And the way I look at it, I mean, these are state paid folks. And as the court has said, we need to have certified law enforcement officers there. And I know our sheriffs, many of our sheriffs are helping out. We over in Orleans County, Sheriff Harlow has assigned her state paid to the courthouse when he's not doing transports. The same with Addison County. And I know the other counties and Sheriff Anderson and Marcoux and also Sheriff Chamberlain have been very, very helpful and assisting the courts with the security. But it's still not enough, and there are still some that are not. I'm not sure what they're doing when they're not doing the transports. They're allowed to do other law enforcement duties. However, I think because of this crisis and the fact that it is one that, as Justice Eaton said, has ripple effects all throughout not just the criminal justice system, but the whole justice system, that it's extremely important to provide that security, get these courts open, get things moving again. So what I'm hoping is that the sheriffs will, in fact, agree with me and agree to reallocate some of the positions temporarily so that we can provide that security. I'll stop there, answer our questions, or let's.
I think
Sheriff
there's one question from me, and that might be better answered by either Justice Eaton or Judge Zone. But what is the need for actual deputies around the state to have all courthouses adequately secure? But I look in Bennington, and there's at any one time, maybe at the courthouse at the state office building, there's like 4 deputies. 2 or 3 are on the front desk when people come in, and then there's 1 or 2 up in the courtrooms. That's 5 to 6 deputies, but I don't know that they need all those all the time. And so I would like to know, what is the actual need to adequately secure our courtrooms? And
I think Judge Zone would be best to answer that.
The odd thing about Bennington is, and I suspect it's true in some other counties, they are at the front gate. And so they're searching people that aren't even going to court. They're going to the Department of Labor, DCF, whatever other state office building is there, except for the Department of Probation and Parole.
I'll let Judge Zone speak to your question, Senator. He can give the more specific answer.
Okay.
Unfortunately, the answer, Senator, is it depends. It depends on the courthouse. As you point out, Bennington and other courts have entities within that structure beyond just the judiciary. And so when the sheriffs are working the front door, they're working it for other agencies. If you're looking at what we have now throughout the state, it changes depending on the function that day. If we're having, for instance, in Woodstock and the Windsor Civil Division, if you're having a hearing that day, you would want an officer at the front door and you want an officer in the courtroom. If you're having a jury that day, you're going to need an officer at the front door, an officer in the courtroom, and you want an officer with the jury. If you're having an incarcerated defendant, you're going to want to, you're going to want to build on that with 2 security officers who are going to be transporting the defendant and monitoring the defendant. Right now, if we took what we have, an immediate need for additional services that we have identified is in Addison County, for instance, we would need an additional rover. The same in Caledonia and Orleans County and Chittenden Criminal also. In Grand Isle, we need a door screener. In Orange, we need an additional court officer.
Could you get those numbers before our next meeting, which will probably be the week after next, to both Stephanie and Eric, of
We can, and
what the minimum is and how many need to be state paid deputies and how many could be. For example, I was in the Rutland court one day, and the former sheriff had actually one of his plain clothes, not a sheriff, but an administrator, who was actually at the door helping the state paid or the deputy sheriff with people coming and going. So he was helping with the screening.
for instance,
I'm
in
curious
Rutland,
as to, pardon?
I believe in Rutland, for instance, on the average day, like you're describing, I believe there are 6 sheriffs who are assigned to that building. That's non-jury trial days.
Right. So it would be helpful to have an idea of what we're looking for in terms of both sheriffs as well as perhaps not, people who, like in Chittenden, I understand there's somebody who's a sheriff doing the initial screening, but inside it's by Securtech. So
We can
I'd
get
like
that
to better
information.
understand is to both Stephanie and Eric, and that would help us at our next time we look at this.
We can do that.
Thank you. John, other
So
questions for
I'll just yield to Sheriff Marcoux, and
Senator
then
White has
take
a
other
question,
questions
I
later.
think. Yeah.
No,
I think the
I
sheriff
don't,
has-
because I think Sheriff
Oh,
has to
yeah,
leave,
he's
so
gotta
I'll
run.
wait. Yeah.
Okay. Sheriff Marcoux. Thank you for being
Good
here.
morning, everybody. Roger Marcoux, Lamoille County Sheriff, and I'm tag teaming with Sheriff Anderson today, who will represent the Sheriff's Association. And I'll just throw out some thoughts here. I have been working with Senator Sears here for a while, both in testimony and offline, to come up with some ideas as to how the sheriffs could help in various situations in the state. And this security situation is something that I'm very, very concerned with, because between 1996 and the year 2000, I was in Haiti working with the Haitian National Police. And because of the security situation there, and particularly the safety of the judges and everything, they had one jury trial in that entire time. So, security so that our courts can operate is really, part of what makes us one of the strongest democracies in the world. A couple of issues for the sheriffs is the money, which we have talked about. And there's a different expense for part-time sheriffs than there is for full-time, obviously. And in years past, since the 70s, we were able to find part-time personnel, and you'd pay them, an hourly fee, and you didn't have to worry about the loaded rate, which is the benefits and everything. Those people do not exist in great numbers anymore. Retirees tend to stay retired. So we're having a very, very difficult time in the recruiting of not only full-time people, which are much more expensive. I think Annie Noonan has stated for a state paid deputy, average price is $50 an hour. But we can't even find, when I can find young people, for example, for Washington County Court, they've been there now for, a couple of years, and they come to me and say, is there any way I can get health care? And who can blame them? So that's a real issue. And I certainly want to make sure that, from my perspective and many of my colleagues, that we're not out there purposely not working court work because we can make more money doing something else. That's not the case uniformly. Certainly, Sheriff Anderson and I find this to be a very serious issue, and we want to be part of the solution. I'll let Sheriff Anderson speak to it, but it seems to me that we were around the $45 mark that the majority of the sheriffs thought that they would have to have, but I'll let him speak to that because I'm not clear about it. But the law enforcement situation, which I've said is a crisis in for a long time, has been the decline of people interested in getting in the business for various reasons. So, and that's affecting us. I am a supporter of taking the state paid deputies, and if they can help be part of the solution, I think that we should work in concert with the courts to be able to make that happen. In my 21 years here, I had the best conversation that I've had with the court on February 2nd with Justice Eaton and Judge Zone. I just felt that there was a real interest in working through this in a partnership, and I'm very, very supportive of that. Couple things. One is maybe to bring to the conversation is the Defender General's office, and particularly when it comes to using transport deputies to perhaps transport some of their clients. In a lot of times, in my experience, it's been for status conferences, just so that the public defender can talk to their clients. And I know that they have a great caseload, so I don't know if there's something that can be worked out to maybe help reduce those transports. So part of the magic here is going to be to figure out what the reality is going to be in terms of the need for state paid or for transports. And in that way, we're going to have to maintain that cadre of state paid transport deputies so that we can not slow the works up by not having enough people to transport. We supplement that with state paid deputies, with per diem deputies. That again is a problem because everybody is short. Every single sheriff's department is short people. But in ongoing talks down the road as to where we're going to transfer the responsibilities or whatever from transports to security, then we're going to have to figure out what is that magic number that we need to be able to do that and be able to do our other job too. And I'm not going to be able to make the sheriff's executive board meeting this afternoon, but the process is going to have to be, we're going to have to talk to all of the sheriffs to see who's willing to participate. And if they're not willing to participate, can other sheriffs work with with state paid deputies to get them in the courts? Couple of things. And I think the court clerks, and I think Judge Zone talked about this about the judges, but the court clerks are going to be an integral part of this too, because they run the operations of their different counties. So, and I'm sure that that'll be worked out with future conversations with the Justice Eaton and Judge Zone. Just a couple of things here before I leave on what I've heard. With respect to county funds, Senator Sears, there is a statute in Title 24, and I tried to find it and I couldn't right off the top of my head, but it does preclude the use of county funds for anything to do with contracts. So Ledge Council might start with that, but it's very, very specific. So that, for example, my patrol people or my patrol contracts, the county can't fund a car for those contracts. So for what that's worth, but that is in there, and it helps really restrict everything.
That's helpful. Thank you.
And then the other thing, and this is completely off the wall, but I have often thought about what it would look like to assist the Department of Corrections with, can a sheriff run a work crew? They know, they would know locally, businesses or what have you, or schools or whatever that might need that. This is completely a Roger Mark who one-off. So I've not talked about this with anybody else, but I think that there's a path there where we might be able to make that work, and just something for consideration. I'll answer any questions. Hopefully I've touched upon some things that are helpful.
But one of the concerns I have, and I don't know if it needs legislation, but John Campbell kind of raised the issue. Could there be one contract where the judiciary contracts with the Sheriff's Association in order to provide more flexibility in terms of the play? And also, I mean, it's kind of ridiculous that the judiciary's, making deals with the sheriff in Bennington County, deals with the sheriff in Orange County to provide this service, that service. I know that one of the things that was worked out with Sheriff Schmidt was fewer hours at the probate and civil courthouse to be open. But that gave the sheriff the ability to pay hourly his deputy a higher rate than he would have otherwise been able to pay. So I'm just wondering if it wouldn't be easier to have I know, you have 14 different sheriffs with 14 different agendas perhaps, but is there a way to give the executive director, maybe the executive committee, more authority to kind of take, if 6 paid deputies are doing 51 transports in Chittenden County, and you have a crisis of deputies available to provide courthouse security, it would seem to me that that's one place you could certainly look. I don't mean to pick on Sheriff McLaughlin, but
from a couple of things. One is that there is precedence for a single contract, because we do that with the Agency of Human Services. Whether all of the sheriffs sign on to it, we've had that conversation in a different, for a different topic. So that has been done. It's one rate, and the challenge, I think, with the courts is that each of the courts have separate needs and what have you. So it's kind of hard to roll all of these separate needs into one contract, I would think. But I think the start to that is the willingness of the sheriffs to have the dialogue and to truly come up with the just commit that we're going to come up with some resolution here. So I'm sure that not answering your question completely, but
I just want to make clear, if it takes legislation, I'm willing to take the hits for introducing it, but it just seems to me that it's illogical to try to do 14 or 12 or 13, whatever Justice Eaton said, number of contracts with every different sheriff. I realize courthouses and sheriffs are independent, et cetera, but you do have an association, you do have an executive committee. I would think they could make decisions. And if it takes legislation, I'm happy to author it or ask Eric to do it. But I also know there's a move afoot, which I don't have an opposition to. I think the Bills and Senator White's committee that would make the state paid deputies part of the union. And it would seem like if there was some uniformity to those positions, it would be easier.
Yeah, well, again, the sheriffs are such an anomaly, is that you can form a union and there can be a negotiation somewhere in the state that provides for agreements, collective bargaining agreements, but then, they work at the will of the sheriff. And if the sheriff can't afford whatever the bargain says, then, or if the sheriff has
I
a
probably
contract-
shouldn't have brought up a bill that isn't even in here and that
Yeah.
Senator White's in charge of, but it was just an example of, if you're going to go that route, then there ought to be some similarity between the jobs.
My opinion is, and it's not shared by all sheriffs, and that's why Sheriff Anderson is going to speak on their behalf, is that there needs to be some kind of centralized organization of the sheriffs in which takes care of the states and the courts' needs, but also recognizes the needs of the sheriffs. Because where else in 2022 is a department working for the state buying? They have to buy their own cars. The sheriffs have to buy the cars to be able to do the work.
Right.
So we've had that discussion, but I think if this is structured correctly and the sheriffs work on it together, that, it seems to me the central office is where to put an organization like that. But, we've had the good fortune of having John Campbell and Nanny Noonan, but we've had not so good fortune of governance there too in the past. So that's a concern.
Okay.
I'll just leave you with saying that we have to, short term, we have to figure this out and where we can help the courts so that they can keep the courts open with a security issue. And maybe this can be done without legislation and through an MOU.
Okay. Senator White has a question or a comment.
No, this is, Roger just said he had an off the wall suggestion here, and I'm going to say that I also have one. And this isn't for the short term, and I know we have to figure out the short term here, but we have, and I don't know if this is even possible because I haven't talked to any of the sheriffs about it, or the court, but I don't know if we need a certified law enforcement officer in each courtroom. If we have certified law enforcement officers available, but we need some kind of security in each of the courtrooms, and then they can call on the rover or the whoever is there. We have and I'm going to talk to Sheriff Anderson about this because he's the co-chair of the Criminal Justice Council, and we have the ability to have what's called a level 1 officer. And it seems to me that level 1 officer could serve as the, instead of certified officers in every one of these locations, and have some certified officers who have arrest abilities available and in the courtrooms, but without having to have, as I think Judge Zone said, in some places, you're going to need something like 8 different people. Do they all need to be certified officers? So I've been trying to get this level 1 certificate going for a long time, and I'm going to push it now. And maybe this is some sort of a long-term solution.
Yeah, the secret again is going to be able to find the personnel to do that.
I get that, but we can't even look for the personnel because we don't have the position yet.
I think my example of the Rutland would be a good one there. You had 2 certified law enforcement officers and 1 person who was not a law enforcement officer at the front gate who was helping people, with their personal belongings going through the conveyor and that sort of thing. But you still had 2 people who could make arrests, do whatever's necessary.
Mm-hmm.
Senator, as part of your earlier question, we'll ask Greg Mosley to put together a snapshot of where we can use personnel other than certified law enforcement and how many certified law enforcement we need.
That would be really helpful.
Yeah, thank you. And remember, these are certified, but they're not fully certified at level
Well-
3.
Yeah, either way, you,
Thank you.
that's, what is the actual need? And what would be the, we're trying to, I mean, I'm certainly supportive of getting to $45 an hour as the judiciary has proposed, but is it all of that needed? Is there a way to get closer to the governor's recommend?
I'll just say that particularly Sheriff Anderson has done a good job of working with the courts on this, this one-off where we're transporting folks back to their communities after court hearings and things. So I think there is precedence through MOUs and things that we have worked, and I have confidence that the rest of the sheriffs are going to want to deal with this and help out. So.
You are closing in on the 11:45. Sheriff Marcoux, thanks for joining us this morning. As always, you're a voice of reason I've found in this committee, and we do appreciate your work. And someday I'd love to talk to you about Haiti. That must have been a fascinating assignment.
Better do it quickly because my memory's going.
Don't speed, Roger.
No, I won't. Thank you very much, everybody. Thank you.
Our next witness is Sheriff Anderson. And I wonder if we could take a 5-minute break before we hear from the sheriff. He's got, I realize you're a busy person. I would be, I need a 5-minute break, and Senator Baruth is not here to take over. If we could come right back in 5 minutes. I don't think you have to go off YouTube, Peggy. I think it just.
Okay.
Jesus. All right. Something is,
It was me. I had my iPad on because I couldn't, my computer seemed to break, and then I got the computer fixed, and then the speaker wouldn't work, and then I just got the speaker fixed, and heat technology.
I know.
Anyway, now I'm all set.
All right. Well, Sheriff Anderson, thanks for waiting to get to you. I think there's some benefit to being the last formal witness. And that is that you've heard what's been said. I think if I might ask you more as president of the Sheriff's Association about creating flexibility through the association to deal with state paid deputies who aren't needed for transports, and the ability for them to do courthouse security, and also some way of having more uniformity on the courthouse security so that every place has got at least one in each courtroom, one certified, what level is it?
One.
One.
Oh, level 1 and level 3 are, and level 2. They're all, yeah.
Okay, at least one with the power.
You'll know what I'm talking about.
Yeah. You know what Senator White's talking about, she said. So go ahead, Sheriff.
Thank you, Mr. Chair. Good morning, members of the Committee on Judiciary. For the record, my name is Sheriff Mark Anderson. I am here as the president of the Vermont Sheriff's Association, and I hail from Windham County. I'm going to try to thread through several different markers, I guess, because as you've mentioned, Senator Sears, I've got to hear a lot of different perspectives, and I think I can provide some clarity to a variety of them as we talk about this common issue. Listening to Justice Eaton speak, I was reminded of Maslow's hierarchy of needs. And if people aren't familiar with it, it's a construct that suggests the order in which organizations can, or really individuals can accomplish different abilities. And right at the foundation of it is security. So without that, I agree that we are not able to see the judiciary move forward without adequate, appropriate, and stable security services. I'm going to start off with obligations of the sheriff. This is all captured in Title 24, and while there's other places that Ledge Council might find various different things, these are the big ones. First off, the sheriff is required to serve and execute all lawful writs and warrants and processes. And this is what will be commonly referred to as civil process. These are a variety of different things, and I think you heard testimony during a prior bill this morning specific to civil documents, and we do not provide the civil arrest, but I won't digress too far there. The second, as we have been discussing, is transports. This is the state paid deputies who provide transports of people from the correctional facilities to the courthouses and back. We're also required, that I laugh at the language, but to preserve the peace and suppress with force and strong hand, if necessary, any unlawful disorder. And in current times, certainly, I think we need to be mindful that we are looking towards de-escalation, not necessarily strong hands, but it does serve as one of the duties of the sheriff. We've also heard from Assistant Judge McKeenan about Stowe v. Lamoille. And one of the things that I bring to light about it is a statement from that Supreme Court case, which said the historical authority has never been held in this state to support the establishment of a paid county police force. This function has been performed by local police forces at the municipal level and at the state level by the state police force. I say that because I imagine each senator and the members of the public who are listening today can think of several places where they've seen their sheriff, and usually it is not in the places I just outlined. In my county, one of the most public and commonly understood things that we do is law enforcement, even though it represents about 25% of what we do from a financial sense. So this is where we start to talk about contracting and the construct of what the sheriff does under contracts, which is what we're mostly known for, but is also not one of our statutorily mandated responsibilities. The Senator Sears, you asked a question regarding funding. And so with respect to brevity, the basic scenario here is that the state of Vermont pays for my salary as the sheriff, as well as any state deputies that are assigned to my department. It doesn't pay for anything beyond the salaries and basic benefits. And so things such as cars, uniforms, computers, licenses to various systems that we need for professional services, we have to find alternate sources of funding for it. The county pays for the facility or specifically the office of the sheriff. And as you heard Assistant Judge McKeeman mention earlier, a lot of the language in all of this is very vague. And so some counties do interpret what those services that they're required to pay for are, but specifically paying for the office is generally interpreted to pay for electricity, heat, telephones. In my county, I think I pay for my internet because it's not incorporated in statute, even though we would probably agree that the internet is mandatory these days, as we're using it right now for this hearing. So many of these things have not been updated, and that's fine. The relationship between the sheriff and the assistant judges, I would say, over the years have developed various working arrangements that do work in each county. And so we have done the best that we can with the language that we have. The county also pays for my bookkeeper or my office manager, as well as my assistant. And so those are two county employees paid for by the county, but they do not pay for any of my deputies at all, specifically their salaries, a majority of their equipment. However, the county is enabled to purchase some equipment. So in my county, that translates to the training ammunition that we need each year for qualification. It also, back about 5 years ago, it's what allowed us to purchase body-worn cameras. So there's different arrangements and agreements that have been established around the state. And I do look forward to the research the Ledge Council or JFO is able to bring up on the differences because each county does have differences. So that leaves finally the department. And this is where a majority of the funds, if not all the funds, are either contract funded or grant funded. That pays for the salaries of deputies, the vehicles, costs such as retirement, healthcare, employer taxes, law enforcement liability insurance, automobile insurance. And so these are all things that we have expenses for that we need to develop a source of revenue to pay for. If we look under Title 24, we are provided with two constructs. The sheriffs are provided with two constructs in which we provide our services, one being the contracts, and that's found under 24 VSA 291A, which specifies the sheriff has to enter into a contract if they provide services for over $2,000. I think this is a good statute. It makes sense. It helps helps maintain professionalism of the sheriffs. But this is also why you heard Justice Eaton mention things like a 30-day out. That's standard language in most sheriff's contracts, as it is in any contract. And so the construct of requiring a contract also requires standardized language that attorneys recommend. And there's reasons to have those things, and there's agreements made by anyone entering into that contract with the sheriff to accept those terms. We have seen anywhere from 90-day terms to 30-day terms, and it has been recently identified that the 30 days was a problem for the judiciary. And so in response to that, we think that that can easily be negotiated through discussion, and I've already begun those conversations. That section also requires that personnel costs, as you heard Sheriff Marcoux testify earlier, they must be covered by the costs of the contract. And so just speaking briefly, when we talk about how much money it costs, if we look at the current, and I'll speak to workforce in a moment, but if we look to the current workforce, most of these positions are going to be full-time positions. The court has already testified that it needs stability. We also want to ensure that there's a perception of impartiality of the deputies who are working in the court. And so to have the arresting officer also be the court officer who is assisting with transactions between either state or defense counsel and the judge is inappropriate. So we generally want to have these people be removed from patrol activities, which then starts to limit the ability that the sheriff has and who they can and cannot assign. When we talk about the costs, again, we have to remain competitive with hiring practices that are occurring around us. And so as we look to certain counties, the applicant pools are challenged. And so we find that we have to pay different wages in different counties to be able to even attract and maintain, retain personnel. And so if we start with even just an hourly rate of $18 an hour, not far above what is being called for in a minimum wage context. This is an entry-level position. We're training them, which means we have to pay them not only for their time, but also for the training, because this is a unique activity. We have to take on that cost. And so after that, we have to pay the federal taxes, FICA, which is about 10.4%. We have to pay workers' compensation insurance, which is about 7.4%. If we're offering a full-time position, we have to pay for insurance, and that can cost anywhere from roughly $12,000 to $28,000 a year. The retirement recently increased for many of the sheriffs, and while I believe it was $45 was proposed prior to the last or in the last biennium, we have seen that increase to 19.6% of the employer's costs and 25% total that is required to go into retirement. So when we talk about how much money this costs, I mean, we are really coming towards the discussion about why the sheriffs need more than $45 an hour. In my case, on average, we saw the retirement increase alone result in close to a $5 an hour increase for the employee's cost. So we haven't discussed other costs associated, such as vehicles, which for a court security officer, a vehicle is not necessarily required. There are some details in which we might need to talk about needing a vehicle, such as if an arrest is made at court, how is that person being transported away? We want to have secure vehicles. There's a statute that requires and causes liability to the sheriff for a person who escapes. So we have every intent and desire for secure transport. We have costs related to the uniform. It costs roughly $2,000 to outfit a deputy sheriff with clothing and insignias, as well as the equipment that they use on a regular basis. We now need to use computers. And so even if it's a shared computer, there's an expense related to that. We also, since they're full-time personnel, we have to talk about paid time off, whether that's sick leave or vacation time, because we do not want to wear out our workforces. We need to talk about the cost of training, holidays. So all of these costs add up into what we have developed as what's now, I believe, $50 an hour, which is what the association has agreed to as a rate. The Vermont Sheriff's Association has negotiated with numerous entities in the state of Vermont, including the Agency of Human Services, on behalf of Department of Corrections, Department of Children and Families, and the Department of Mental Health, to come up with uniform contracts. And so to the point of Justice Eaton and having to maintain 13 contracts, we don't need to do that. And I'm not sure why that never occurred with the court contracts. It was before my time as sheriff. However, we spoke with the judiciary probably about 3 months ago, where we did raise that, hey, this is certainly a possibility, but it hasn't come through a contract cycle yet, so it hasn't yet occurred. But well within our abilities currently, and so I don't see, in terms of contracting, I don't see a need for statutory change for any sort of contract relationship with the court. My conversations with sheriffs across the state, while this is not a unanimous feeling of each sheriff, I think there is a commonality that sheriffs generally want to partner with the judiciary. We want to provide the service. To provide the service at our cost has generally been the desire. We are not looking to get rich. We are not looking to do any of these things that relate to higher wages, higher revenue streams. When we contract with other organizations, such as a construction company who's paving, we're also paying overtime rates. We're bringing in revenue to the department that helps us offset or subsidize the purchase of vehicles or computers, or subsidizes our patrols in towns, which are also contracted, and we also provide those usually at the cost that we provide that. So to that end, there's a general desire. I've spoken with Sheriff Sponiak, Sheriff Chamberlain. You've heard from Sheriff Marcoux. I've spoken with Sheriff Harlow and several others who generally want to help. How we get there, what road we take is part of the details in the discussion that we've already initiated with the judiciary as they've identified this issue. And we have willing partners. There's also constraints that we deal with. Actually, before I get to the constraints, the second construct, which I haven't discussed yet, but you're well aware of, is that we do have state paid deputies. So of the three budgets that we talk about, again, the state paid deputies, their salaries and benefits are paid for by the state of Vermont through the Department of State's attorneys and sheriffs. Again, it does not cover the cost of their equipment or any of those other things. But to that point, when we talk about the court, we have lower costs in terms of what we need. If we had transport personnel who could alleviate a court officer paid by the state of a person in custody, then that obviously removes the need for a cruiser to be assigned to that individual. So there are details that would need to be pulled out, but certainly I think a healthy conversation, a conversation the sheriffs are willing to participate in. If we talk about the responsibilities of the state paid deputies, statute requires or dictates that the state paid deputies are people who primarily provide transport services. You've heard some statistics from Director Campbell regarding the decline in transports. Some of those are certainly, all of it is in relation to the pandemic. So the sheriffs are aware, the sheriffs who are assigned state deputies are aware that there has been change. There's an acknowledgement that technology is capable of doing things that were not previously accomplished. One of I believe this committee, but certainly committees of jurisdiction have heard testimony from now retired Judge Grierson, who spoke about one of the troubles of the remote hearings, which relates directly to the post-hearing transport program that we initiated after COVID or during COVID. And really what that was instead of a prisoner who is in custody in a courtroom who's released from Brattleboro. They were arrested in Brattleboro. They were released from Brattleboro. What happens now is they're arrested in Brattleboro. They're transported to Springfield, not by their own means, and then they're left to thumb it, to find public transportation, to potentially arrange their own transportation, or in one instance, break into and steal a vehicle and return to Rutland County. That's a case that did occur, I believe, in 2020. So the idea of our program was, if we're going to remove a person from the jurisdiction that they were arrested in, we should have a responsibility to return them to that jurisdiction. And so we're returning them from the regional correctional facilities to the courts. State paid transport deputies are also working to support the Department of Corrections, who have had a significant reduction in personnel for a variety of reasons, which I'm not here to testify about, but certainly we are working to help support them, whether that is in facilitating and helping with the movement of personnel inside the facilities, which is not our preference, but we are doing it, or inter-facility movements. That's moving someone, say a female incarcerated at Southern State facility to the women's facility in Chittenden County. So we're assisting with that. We've had a request that we help support with physical security at the facilities as well, which we are already starting to work through. And how these relationships work have generally been, we've identified with the various departments that we would like to accomplish through an MOU with the Department of State Attorneys and Sheriffs and with DOC. So many of the things that you've heard about today, and whether or not we need to capture in writing, in the format, whether it's statutory writing, contractual writing, MOUs, most of this we can already capture under our contractual language or through standard practices with memorandums of understanding.
I have a couple of questions that you've raised, and thank you for the testimony. I'm trying to stick with two basic issues. One is courthouse security in the short term, and then in the long term in FY23. So in the short term, if there were flexibility for the executive committee or the executive director and Annie and John to work through helping with courthouse security, using some of the state paid deputies that aren't needed for, my understanding is like if there's only 50 transports in Chittenden County and they have 6 paid deputies, they obviously don't need all 6. So maybe some of them could help with courthouse security. That's one immediate thing. I'm a little confused. The sheriffs, I think I heard you say that to do courthouse security, you need like $50 an hour. The judiciary was talking about $45 per hour. And I think the governor's FY23 budget, if I can't really figure it in hourly, but is like $30 an hour. Is that somewhere near accurate? I mean, that's where we're at. So actually, when we're making recommendations to the Appropriations Committee, we may want to be making recommendations above what the judiciary asks, which is what, and that's why I'm hoping Judge Eaton and Justice Eaton offer to come back with what the real need is and where we can do that. But clearly, if we're actually $15, $20 apart versus what the sheriffs feel they need and what the governor's put in the 23 budget, we've got a problem that needs to be resolved. And so in the long term, I had, worked on some ideas of language that would allow the one contract and allow the executive director of the state's attorneys to work, and the executive committee of the state's attorneys and sheriffs to work together on this issue. But you said that one contract would make sense since you have one contract with AHS, basically. Did I hear you correctly?
Yes, Senator Sears, you did. And to to your first question, we are already working to do that, and some counties have already, though I think it's, I won't say formally, they have assigned their personnel to the courts already. I believe Addison County has used their state paid deputy to provide services to one of their courthouses. Windsor County has stationed their deputies in the White River Junction courthouse. My deputies, when they're not doing the post-hearing program, have been at the courthouse. So we've already begun this, what I'll say is assignments to it. What we're currently talking about and what the Executive Committee for the Sheriff's Association will be talking about later today is the how do we formalize the need that's been identified by the judiciary. We did this of our own accord. We needed a place for them to go. We identified the courts as places where these people could be, but we didn't know the roles that they needed to serve. And so that's the communication that has begun with the judiciary. And we've just yesterday, we received a list of the specific needs of each courthouse and how we can do that. And so today's meeting with the Executive Committee of the Sheriff's Association is to do exactly what you're talking about and help with the short-term problem. Towards the long-term problem, they're certainly commingled, but we can also talk about them separately. Towards the long-term problem, we want to make sure that when we receive funding from the state, that we are using it appropriately. For the same reason that when $110 million was announced for the ARPA funds for the counties, we said we don't need all of that. The sheriffs and the counties are small piece of state government or of the state of Vermont, but we do need some of it. And so this is an example of saying we have needs, but we don't necessarily need everything. And so how does that look? Our last estimate was that we had about 40 to 45 personnel from the sheriff's organizations across the state under contract with the judiciary to provide services. So we currently have 25 state deputies. So maybe one of the things we consider looking towards budgets of the future is, do we increase numbers of state deputies to handle not just the court security, but also consider how transports need to evolve and will evolve over time, and what the needs are with remote hearings. There's still a need with the regional centers to transport them, but also there's a need for people to come to hearings, even if that's reduced. There's a need for people to be transported during trials. So there will be a transport need. Senator Sears, I hope I answered your first question. I apologize. I forget your second question.
Well, it was more about the money. I think that you answered that. I think I'm clear as where the difference between what the judiciary was requesting and what you actually need is relatively minor. The difference between what the governor put in his budget and what you actually need is huge. If I might, just from an appropriations committee standpoint, the Senator Nicker and I and Senator Bruce are all on the appropriations committee, and I would say that's the difference. I mean, it would be easy to make up the $5 an hour difference between what the judiciary requested and what you're looking for. It's going to be difficult to make up roughly $20 an hour.
Senator Sears, I agree, and I appreciate that. And one of the main reasons for the increase from the 40,
which may be helpful, which I might add, might be helpful, is Senator White's suggestion. I think Justice Eaton suggested that there may be places where you don't need level 3 or whatever level we're talking about.
Yeah, and Senator Sears, I appreciate that. The reason, if I didn't mention it, the reason for the $45 versus $50 disparity was really the retirement increase that occurred in July. So that's a fairly new evolution. And as contract negotiations begin, then the judiciary would be apprised. But with Judge Zone and Justice Eaton here, I think they already know our reasoning for that. Speaking about levels 1, 2, and 3, I would be remiss if I didn't share. There's obvious workforce issues. This is across various industries. I know you've heard testimony to that in other hearings. There's been probably about a decade's worth of workforce within law enforcement where hiring qualified candidates with heightened standards has become more difficult. There is more recently, in the last 2 years, there is an even greater stress on hiring law enforcement officers across the state, and I'm sure you've heard testimony to that as well. So I can't say that being able to access qualified personnel is going to necessarily be the easiest thing, but certainly we're also not. It's not a number of 0 people who are getting hired. It's just how are we able to hire them and what time frame? For me to stand up, when we used to have a contract with the judiciary, for me to stand up 7 people to provide the court security in all the Windham County courthouses, that was the number that we used to provide. To do that, I need time to hire them, train them, and do those things. It takes 6 to 12 months just to accomplish those things. The Level 3 Academy is a 16-week school that then has follow-on field training. So we're talking about half of a year that they are spent just in training. Is that necessary for a court security officer? Absolutely not. The Level 2 training, which is what we currently use for court security officers, that's a 2-week school, 80 hours, followed by roughly another 200 hours that are accomplished across a 12-month period. That is with the person's directly supervised. They work with a field training officer. They attend classes that are required by the Vermont Criminal Justice Council and whatnot. The problem is
we have to go to the floor at 10:30, and it's 10:20 now. So I kind of would like to wrap up. And if Stephanie and Eric have all the information they need, Sheriff, we're going to come back to this at some point in the near future, probably week after next. And Justice Eaton and Judge Zone, have you got what you need, what we're looking for?
We'll get on it. We know what you're after.
Thank you. I thought you left us, Senator White, but your computer issues. Eric, I've got some ideas of language that I will try to get to you for the 23, to be effective in 23, that would provide flexibility. And Stephanie, do you have what you need?
I do.
Senator Sears, are you thinking language for the budget?
Yeah.
Okay. Yeah, just send me whatever ideas you have and I can work on it.
Okay. And we can work with the Sheriff's Association and Justice Eaton or Judge Zone, as well as Stephanie on the language.
Yeah, and the dollar amounts that you're.
Yeah, there's also some fees I'd like to look at. The sheriff mentioned, I don't know if we can do that in the budget or if I need to do a separate bill or where I do that, but I need to look at. He mentioned that the fees for service is one of the responsibilities, and they haven't been updated in 15 years.
Senator Sears, do you want to do that on February 23rd, the week before, the Wednesday before town meeting?
Yeah, that'd probably be pretty good. Don't want to do it on Washington's birthday. I still celebrate, with cherries and stuff. The 22nd. So, I mean, I'm aware of the real birthday. President's Week kind of messes everything up. But
Do you do Lincoln's also on the 12th?
I do. I actually have an old Lincoln jug from, the syrup. No, as a kid, my mother always baked a cherry pie on the 22nd.
We always cut down a tree.
That's rather wasteful, Senator.
Sorry, I couldn't help myself.
I understand. So, yeah, the 23rd sounds good, Peggy. Is that good for everybody else? Because I really want, I think this is an emergency, short term, but also long term.
Senator, the Supreme Court's in term on the 23rd, so I can't be there, but I hopefully Judge Zone can come.
Would the 22nd work better?
Yes.
Or the 4th? Would the 24th work better?
Either one.
Okay, why don't we do the 24th, Peggy? That's the Thursday. The
Okay.
reason being, I never know when we're getting off the floor on the 22nd, on the Tuesdays.
Yep.
So
All
we'll do
morning?
the 24th. Yeah, yeah. We want to invite corrections, but if we can, if you can summarize why, I forgot now why we want corrections. Oh, on the transports and the issue of the Judge Zone, if maybe you can just remind me. It's the issue of getting the technology and all that and signing the papers. And we want the Defender General here too, because they're asking for people to show up at status conferences just so they can talk to them. And is there a better way to do that? So forth. Is that what, am I recollecting?
I believe the sheriffs indicated about the status conference aspect with the Defender General. And yes, the question that came up with respect to DOC had to do with really making them more available to assist us in getting paperwork taken care of, as well as the resource of the technology so that we don't have to treat people.
And with their staffing crisis, do they need help with transports as well? That's another question. Oh, God. All right. John
As
Campbell?
Chris Pearson says, this session, we seem to be jumping from one crisis to another.
Well, if we can't get the courts open, there's obvious people's access to justice is not available. And when that's not available, you have situations that aren't good. And, you know, it's not just the criminal side, by the way. If civil cases are so backlogged that people can't have their regress dealt with, it often ends up in more difficulty.
Can I just quickly ask Judge Zone a question?
Sure.
Do we have, I'm thinking of, I haven't been there for a while, but the Windham County Probate Court, I don't think they have any security.
Probate court is part of the criminal and family building. I believe that moved there.
Oh, it moved. Okay, I haven't been there for a long time, and I was thinking of them on Flat Street then. Okay, thank you.
They're
Yeah.
in the regular courthouse now, I believe.
Okay, great.
And also, if we could get an inventory of where the courthouses are county owned and where that having the HVAC and et cetera versus those that are state owned. And
do
what
that
those
also.
counties need to get up to speak, if there are any counties who need ARPA help to get up to good standards. I think that's one thing that when the sheriff reminded me of when he mentioned that they were going to get all that county money, and they said they didn't need it all, but they could use some. I think some of the counties needed some money for county courthouses. And I don't know if Stephanie, did we fund that? Did we fund any of that? County courthouses?
I don't believe we did.
Can I, Judge, the side judges did a survey to see what they would need in all the county courthouses, and they brought that to us. It was $12 million. We actually put it in the budget. We asked that it be put in the budget. It was taken out of the budget by Judiciary, and they said they would deal with it another way. It was 12 million.
Senator Sears, I have to go and find my jacket
Yeah, I know.
before the floor.